here, Bishop Bobby Hilton. Someone has pretty much said, we're kind of biased toward Tracy Hunter. It's been said already. So how do you respond to that?
We're not biased at all, Lincoln. I have a connection to the Buzz. The Buzz has allowed me, because I have a show here, to get a word out. And because this has been the vehicle that I have been able to use, there's no better place for this to happen than right here at the Buzz.
All right. Well, it's already been questioned as to why. Okay. I'll let you introduce the Hamilton. I don't have her name. What's her name?
Okay. I'll introduce her name in just a moment. Okay. Thank you, Lincoln, and thank you, ladies and gentlemen of the press that are here and everyone listening. I am Bishop Bobby Hilton, president of the Greater Cincinnati chapter of the National Action Network. Since November 2010, we have witnessed what I would describe as just a travesty. It took 18 months in the courts to get provisional ballots counted and to find out that indeed Judge Tracy Hunter was the winner of the November 2010 election for Hamilton County Juvenile Court. In the meantime, the opponents found a way to seat her up, to seat the person that she won against. Judge John Williams was seated before she could get seated, and all authority, or the administrative authority of the court, was placed in his hands. Every possible method that could be thought of has been thrown at Judge Tracy Hunter to take away any authority that she would have in the court. She can't even hire people. Everyone she tries to hire is turned down. Recently, about 18 lawsuits were filed from the Hamilton County Prosecutor's Office against Judge Tracy Hunter. And these lawsuits were about her having cases out of time. An attorney hired personally by Judge Tracy Hunter found out that Judge John Williams had more cases out of time for this period than she did. But no one investigated that. No one spoke against that.
Or ever reported that.
Or ever even reported that.
Or wrote a story about that.
Exactly right. Exactly right. Cecil Thomas and myself went to the Hamilton County Commissioner's Office meeting, I should say, last week, because we'd heard reports that, well, all of the Supreme Court found against Judge Hunter in these lawsuits filed. So we went to the commissioners' meeting and we asked the question, wait a minute, county taxpayers are paying for attorneys that have been appointed to represent Judge Hunter. And we're hearing that they did not write one answer in response to all of the lawsuits. County Commissioner Toppertoon said he would look into it and investigate it, because surely we don't have two attorneys being paid for by county taxpayers and they're doing nothing. I got the report back from Hamilton County Commissioner Toppertoon, and he said not one answer, not one, was filed on behalf of Judge Tracy Hunter. So the findings from the Ohio Supreme Court would be automatic. If you don't answer within 28 days, you're going to have an answer come down against you. So here we are today with an individual, and it's very important to understand that this is not about Republican or Democrat. It's not about black or white. It's about what is wrong and what is right. So we are pleased to introduce what I believe is only the first of individuals that are saying enough is enough. What's really going on within the Hamilton County Juvenile Court? Why were her opponents willing to spend nearly $2 million of taxpayer money trying their best to keep Judge Tracy Hunter out of there? And why is an investigation going on even now, trying to find a criminal charge against the judge? Subpoenas have been sent out to so many people around Judge Tracy Hunter, including her brother, including her attorney. Why would a subpoena be sent to Judge Tracy Hunter's attorney? And they're going before the grand jury this week. The continued attacks are ridiculous, and we want to know what's really at the bottom of all of these attacks. So I'm pleased to introduce Susanna Meyer, and I'll allow her to tell her story from here.
I am attorney Susanna Meyer. I worked for the Hamilton County Public Defender's Office from January 2010 till January 2013. While employed by the Public Defender Office, I challenged more lower court decisions than any other attorney in my division, other than the former Chief Appellate Director. Prior to the arrival of Ray Fowler as Chief Public Defender, I was selected to attend the National Criminal Defense College in Macon, Georgia. I received the Golden Gavel for outstanding work in municipal court on a motion to mitigate, and I obtained an excellent evaluation from the appellate division supervisor. I represented clients in the juvenile, municipal, felony, and appellate divisions. I was fired from the Hamilton County Public Defender's Office by Chief Public Defender Ray Fowler 2 days after filing a brief alleging prosecutorial misconduct. At 3:20 p.m. on January 2nd, 2013, Ray Fowler called me into his office. He coldly stated that since he took over as chief of the Public Defender Office, that, quote, I have made the decision that the office is best served without you, end quote. I was then told that I had 30 minutes to remove my personal items from my work area and turn in my ID badge and keys. I had no disciplinary record. When my immediate supervisor asked why Ray Fowler had made that decision, Mr. Fowler stated it was in part because former juvenile Judge Grady had banned me from her courtroom and that the juvenile magistrates did not trust me. While working in the juvenile division, there was a case where I had filed for discovery and subpoenaed a police cruiser video. After I did not get it, I filed a motion to compel the prosecutor's office to provide the video. After the hearing, I was summoned to the former juvenile court Judge Carla Grady's chambers the next day. Then, with my juvenile division supervisor present, former juvenile Judge Grady ripped me to shreds, filing the motion to compel discovery of this cruiser video. In another case, while in former juvenile Judge Grady's courtroom, the judge asked me, quote, do you have to file objections to everything? End quote. Meaning, did I have to continue to challenge the decisions of the magistrates? I only objected to the decisions of the magistrates when it was in the best interest of my client to do so. Similarly, after an objection hearing in front of former juvenile court Judge Grady on a case that I had tried, I was told by one of my co-workers not to appeal the judge's decision denying the objection. She stated that at the hearing, the judge had indicated that the child would be sent to the Department of Youth Services instead of a treatment program if I challenged the decision to a higher court. Later, the interim juvenile court division supervisor, David Montgomery, told me that he had been questioned regarding appeals and objections that I had filed on behalf of my clients to Judge Grady. I was then instructed that I was not to file any more objections, appeals, and certain other motions without prior approval and screening. However, to comply with that instruction would render my assistance of counsel ineffective in some cases. Therefore, I filed the motions anyway when necessary. On October 22nd, 2010, in response to David Montgomery being questioned, I wrote a letter to the Chief Appellate Director stating, quote, we are advocates. We took an oath to zealously represent our clients. So now someone wants us to back off, violate that oath, turn the other way? Sounds like a conspiracy to violate due process by instituting a policy that prohibits effective assistance of counsel, end quote. Shortly thereafter, I was removed from the felony rotation list, and my caseload was reduced to 0. I found many areas of concern, in addition to being instructed not to file objections, appeals, and certain other motions on behalf of my clients during my time as a juvenile division public defender. Specifically, Terry Weber, the former supervisor of the juvenile division, quote, ordered me not to subpoena records from Job and Family Services which were relevant to a case that I was going to trial on. He said that he was ordering me not to subpoena the records because he, quote, did not want a call from Joe Dieters, end quote, the prosecutor. I was so distressed at this instruction that I called the Ohio Supreme Court Attorney Ethics Line to ask for guidance. I was told by the ethics representative that if there is evidence relevant to the defense of my client, that I had to present it. So I did. These are just a few of my experiences while representing children in juvenile court. When I first started working at the office, several co-workers stated, quote, as long as you don't piss off the magistrates and the prosecutor or the judge, you will be fine. And in reference to an appeal that I had filed to the judge's decision, I was told, quote, if you're going to shoot at the king, you better make sure you take him out, end quote. The juvenile division supervisor, Terry Weber, told me that the magistrates felt that I had represented my clients too zealously and that, quote, everyone hates me, end quote, because of my filing of discovery requests, objections, and appeals. Given the obstructions placed before public defenders, in many cases, I was prohibited from effectively representing my juvenile